All right, everyone, welcome. Today, we're diving into one of the most crucial parts of our Constitution, Article 16. Now, if you really want to understand the promise of equality in India and all the complexities that come with it, this is the article you have to master. It's so much more than just a dry legal rule. Think of it as a living, breathing story about how our law, our society, and our government are constantly in conversation with each other.
So here's our game plan for today. We'll start with the big promise of equality at the heart of Article 16. Then we'll look at the exceptions, the buts, and howevers that the Constitution itself creates. From there, we'll see how the Supreme Court laid down some major rules, how Parliament pushed back, and of course, we'll get into the very recent, very important EWS quota. And at the end, I'll give you a quick briefing on exactly what you need to remember. So let's jump right in.
Okay, first things first. Before we get into all the debates and exceptions, we have to understand the foundation. What is the core, the absolute baseline principle that Article 16 gives to every single citizen? This is our starting point.
And here is Article 16, Clause 1. This is the bedrock. It basically says that when it comes to getting a job with the government, every single citizen gets an equal chance. That's the default rule. Think of it like this. The Constitution draws a single starting line, and in theory, everyone starts from there. It's a fundamental promise of fairness.
Now, this is where it gets interesting, and this is a key detail for anyone studying this closely. Article 16, Clause 2, lists the grounds on which you cannot discriminate. It looks a lot like Article 15, right? But look closer. It adds two extra grounds, dissent and residence. Why does that matter? It shows you just how specific the framers wanted to be about public employment. They were trying to plug every possible loophole for discrimination in this specific area. It's a subtle but really important point.
Okay, so we have this beautiful promise of equality. But the story doesn't stop there, because the people who wrote our Constitution were realists. They knew that you can't just declare everyone equal on paper and expect centuries of inequality to vanish. A fair start isn't fair if people are starting the race from miles behind. So they built in exceptions, on purpose, right into the fabric of the article.
And this is the big one. Article 16, Clause 4. This is the constitutional source for reservations in public jobs. Now look at the wording very carefully. It says the state is empowered to make these provisions. What does that mean? It's not a command. It's an option. It's a tool the government can use if it finds that certain backward classes are not adequately represented. This is the Constitution moving from just preventing bad things, like discrimination, to actively trying to do good things, like ensuring representation.
So for decades, this power was used. But then came the 1990s and the Mandal Commission. The government's decision to implement a 27% quota for other backward classes, well, it set off a firestorm. It led to massive protests, huge political debates, and inevitably a major challenge in the Supreme Court. The court had no choice but to step in and try to settle things down by setting some clear rules.
And this really was the million-dollar question before the court. Okay, the Constitution says the state can make reservations, but how far is too far? Is there a limit, or is it a blank check for the government to do whatever it wants? Can you have 70, 80, 90% reservation? This is what a massive 9-judge bench had to figure out in what we now know as the landmark Indira Swahani case.
And the court's answer became one of the most famous rules in Indian constitutional law. It came down to a single number, 50%. The court drew a line in the sand and said, listen, as a general rule, you cannot have more than half of all jobs reserved. This 50% ceiling became the defining feature of reservation policy for almost 30 years.
But wait, the court didn't just stop at the 50% rule. It laid down a whole framework, a set of guardrails. First, it introduced the concept of the creamy layer, saying, okay, within the backward classes, the more affluent, the more advanced sections, they have to be excluded. The benefits must go to those who truly need them. Second, it said no reservation in promotions. And third, and this is absolutely critical, the court declared that reservation is not a fundamental right. An individual can't go to court and demand it as their right. It's just something the government is allowed to do.
So the Supreme Court has spoken. But in a democracy like ours, that's rarely the end of the story. It's more like a conversation, a bit of a tug of war between the courts and Parliament. And Parliament had a pretty strong reaction, especially to one part of the court's ruling.
And what was that part? The ban on promotions. The court said no reservation in promotions. Parliament's response? They went ahead and amended the Constitution. That's right, they didn't just pass a law, they changed the Constitution itself just 2 years later. They added a whole new clause, Article 16(4)(a), which basically said, yes, there can be reservation in promotions for SCs and STs. A direct counterpunch.
So the ball is right back in the Supreme Court's court. Parliament has made its move. What does the court do? Well, in a case called M. Nagaraj, the court said, okay, Parliament, your amendment is valid. You can have reservations and promotions. But there's a catch. The court put in place 3 very strict conditions. It said for any promotion quota, the government has to prove 3 things with hard data. 1, that the community is still backward. 2, that it's not adequately represented in those specific higher posts. And 3, that this whole thing won't mess with administrative efficiency.
Okay, so for decades, this was the system. You had caste-based reservations, you had the 50% cap, you had the creamy layer. That was the settled law. But then in 2019, something happened that really changed the game. It introduced a completely new idea into the reservation debate in India.
And this new development brought that old 50% ceiling right back into the spotlight. So we have to ask, was that rule from the Indrasani case set in stone? Was it a sacred, unbreakable limit? Or was it just a guideline that could be bent or even broken? Well, the 103rd Amendment in 2019 gave us the answer. It introduced a brand new clause, Article 16(6), and created a 10% reservation for economically weaker sections, or EWS. Now, this was a massive deal for 2 reasons. 1, for the first time ever, we had a reservation based only on economic status, not caste. And 2, this 10% was on top of the existing 50%. It blew right past that ceiling.
Of course, this immediately went to the Supreme Court. And in 2022, in the Janhit Abhiyan case, a majority of the judges gave it the green light. They upheld the EWS quota. The majority opinion made 3 really critical points. First, they said, yes, reservation can be based only on economic criteria. Second, they declared that the 50% ceiling is not rigid. It's not a hard and fast rule, and it doesn't apply here. And third, they said it was okay to exclude the SCs, STs, and OBCs from this new quota because they already have their own reservations.
All right, that was a lot of information, I know. So let's switch gears into a final briefing. Think of this as the what you absolutely must remember for the exam section. Let's boil it all down.
Here's a simple way to organize this in your head. For Article 16(4), the reservation for backward classes, you need to think Indrasani. For 16(4)(a), reservation and promotions, the key case is M. Nagaraj and its conditions. And for the newest one, 16(6), the EWS quota, it's all about the Janhit Abhiyan case. Link the clause to the case and you're halfway there.
And a few final, crucial points to hammer home. 1. Article 16 is about public employment, and it's for citizens only. Don't mix that up. 2. Remember those 2 extra grounds that are unique to Article 16(2? Dissent and residence? That's a classic exam question. 3. Indrasani is your shorthand for the 50% ceiling and the creamy layer. And finally, you absolutely have to be on top of the Janhit Abhiyan case. It's the most recent major development, and it's a total game changer.
So I want to leave you with this one thought, a direct quote from the Indrasani judgment. Reservation is not a fundamental right. What does that actually mean? It means it's not something a person can claim automatically, like the right to free speech. Instead, it's a tool, an enabling power, that the government can use to try and fix historical injustice. It's a means to an end, with that end being a more equal society. And that leaves us with the big, ongoing question that the Constitution is always asking. Are we using the right tools, and are we using them in the right way to finally reach that goal?